We gave, I have to say, we had Alice give the pep talk to the kids. So we're ready to start.
Unit 4 was a little behind, but we're ready to go.
Okay, and so are we. And I'd like to say, I'm Marcy Taylor Toma, Dr. Toma. I'm the Executive Director of the Maryland Council for Civic and History Education. But more important than that, I started out my career as a social studies teacher and a We the People teacher. So the judges will introduce themselves to you now.
Well, good morning, Massachusetts. It's great to see you, and warmest congratulations in winning your state and participating in the national finals. My name is Matt Gutwein. I'm from Indiana. I'm retired, but I previously taught constitutional litigation and civil rights at the Indiana University Maurer School of Law. And I'll let my fellow judges introduce themselves.
Hi, I am a State Senator Anna Terry Flores. I'm a state senator in Miami, Florida. And I participated in the We the People competition several years ago. Our team won the national championship that year. So I know you all are feeling nervous and anxious. So take a deep breath and we know you'll do a great job.
Good morning. My name is Gus Chin. I'm a municipal judge from Utah.
All right, would you please introduce yourselves to us?
Hello, my name is Iman Olbeed and I'm a junior at Easthampton High School.
Hi, I'm James Aquino and I'm also a junior at Easthampton High School.
Hi, I'm Elizabeth Winberg and I'm a senior at Easthampton High School.
And your teacher, please?
Our teacher, Kelly Brown.
All right. Well, thank you very much. So this morning, we are going to talk about question number 1. A result of the decision in Wisconsin versus Yoder is that, quote, any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about any subject by saying it's against the religious beliefs, end of quote. Do you agree or disagree with the result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights?
In Wisconsin v. Yoder, the Supreme Court opined a narrow finding that Amish parents can remove their children from school in the 8th grade. We agree that Amish teenagers should not be compelled to directly violate their religious beliefs, but agree more with Douglas's dissent that it should be up to the child as it is their future. Despite what is implied in the quote, the Yoder case was a narrow finding and fell short of making any universal declaration.
At the time of Yoder's ruling, free exercise cases were uniformly under strict scrutiny, as decided in Sherbert v. Verner. The status of free exercise as a fundamental right, incorporated into the states in Cantwell v. Connecticut, gave it precedence over a right like education that has not yet been declared fundamental. However, in 1990, Smith v. Oregon ruled that if a law restricting free exercise is neutral and applied to the general population, it only needs to pass a rational basis standard. Considering that development, a case like Yoder might be decided in the opposite direction today.
The right to religion is established in the free exercise and establishment clauses of the First Amendment, whereas the right to education is not written in the Constitution, and San Antonio Independent School District v. Rodriguez determined that education is not a fundamental right. We dispute this ruling as we believe education passes the Glucksberg test of having a historical precedence and being necessary for ordered liberty. Currently, federal education protections are found in the Equal Protection Clause of the 14th Amendment, which mandates that states have to give everyone public education if they're going to give it to anyone. For example, Plyler v. Doe stated that undocumented immigrants must be allowed to attend public schools.
While state education provisions vary, all 50 states have recognized the right to education. This has led to much stricter education protections in some states, such as Wyoming, where Campbell County School District v. State ruled that the state had to provide the amount of school funding determined necessary to provide a complete and uniform system of public instruction. Some states have also recognized stricter equal protection requirements than the Supreme Court. In Serrano v. Priest, the California Supreme Court ruled that a school funding system relying heavily on property taxes was unconstitutional.
In order to assess the court's protections of religious liberty, it's useful to revisit the origins of the First Amendment's protections for religion. The framers believed virtue was fundamental to a functioning democracy, and freedom of consent without state-sponsored churches was most likely the pathway to education of virtuous citizens. The balance of religion with other rights is seen a level of scrutiny used in different religious freedom cases. In many cases, religious liberty will prevail, as a violation of specific religious beliefs will be held to a standard of strict scrutiny as established in Sherbert v. Werner. But cases involving religious liberty are not so simple, as they involve a state's police powers and not two individual rights in conflict. Additionally, as mentioned earlier, the court has given broader latitude to states, complicating the strict scrutiny protections of religious liberty.
Congress has been a strong advocate for free exercise. In response to Smith v. Oregon weakening the Sherbert standard, Congress's Religious Freedom Restoration Act attempted to create legislative strict scrutiny standard for free exercise cases. City of Bernie v. Flores declared the RFRA partially unconstitutional. Today, federal free exercise cases are considered under strict scrutiny, while state and local cases follow the Smith test. The Establishment Clause is more controversial. In 1971, Lemon v. Kurzman introduced the Lemon test, stating that laws must serve a secular purpose, neither promote nor restrict religion, and avoid unnecessary government entanglement. The court has often upheld the most absolutist policy in terms of schools seen in Lee v. Wiseman and Santa Fe Schools v. Doe. However, outside the schools, the court has ignored the Lemon test in order to promote historic and cultural traditions. In American Legion v. American Humanist Association, the court ruled a 40-foot cross constitutional and said that the Lemon test did not serve its purpose in religious monument cases. Instead, monuments must demonstrate a secular and historic purpose. Thank you. We're ready for your questions.
Well, thank you very much. I'll start with the first question that relates to what's happening in the world today. So how would you analyze local schools that require, as a matter of law, all students to be vaccinated in order to return to school, and that some parents have religious objections to being vaccinated, and the schools allow certain exemptions, for example, when children are ill or allergic to those vaccinations, but do not allow religious exemptions? How would you analyze those cases?
I would analyze those cases similar to how we see Wisconsin v. Yoder. We see that inside Wisconsin v. Yoder, religion is held to a standard of strict scrutiny, unlike we see with education. So I feel that even though they do, I feel that they would have to agree with the religion, unlike, I feel like they'd have to agree with religion more in this case, because religious liberty does prevail because it is protected by strict scrutiny.
I definitely agree with what James is saying, but there's also the common good, because right now we're in the middle of a pandemic, and I can understand that because your religion would prohibit it and not want you to be able to get it, but it's the common good, and being able to go to school, you also need to go to school, because that's, if you're looking at it how Madison might look at it, that's how you create virtuous citizens. And that was really important to be able to have a good democracy and people be able to participate in the government. So I think that it's really complicated in however you're going to look at it.
Great. So I'm gonna throw out a bit of a hypothetical to you. The case of Wisconsin versus Yoder with the Amish community, which is something that we know. What if there was a religious organization that had a deeply held religious belief that girls should not have a formal education and should not go to school, and this was just something that was readily accepted in their religious society? How do you think courts would handle an argument that their religion feels that girls should not go to school, and how would you balance that?
I would say that it would be held to the standard of like what Yoder is. Like basically they give religion the precedent because it's in the Constitution and like it falls under strict scrutiny. So I believe that it would be the same case as Yoder. But like I feel like that some people may be like given a choice if they want to like step away from their like parents and stuff. Like in Yoder, like in the dissent basically we said that like sometimes a child should have like the choice of like going back into school and not being taken out. But like we don't give them the choice to like leave school on their own. And so I feel like it'll be the same it'd be in the same sense as this.
think that by denying girls education, I think that violates the free exercise, not the free exercise, the due process, no, the equal protection clause of the 14th Amendment. So I think that it really does violate that, and that you shouldn't be able to just say that they can't go to school, because I think that really violates the equal protection clause.
I agree with Liz. I think that we could also see that Yoder was a narrow case, so it wasn't a universal decision that everyone has to follow that ruling. So I believe that it does violate that equal protection.
Thank you. Given what you had said, that you had mentioned the choice of the child or the student, how do you balance the parental responsibility for welfare and well-being of a child versus the child's desire for an education to pursue life, liberty, and the pursuit of happiness?
Well, I mean, in this specific case, the child's liberties are at stake, not the parents. So giving these children a choice at such a young age, especially like in Wisconsin v. Yoder, they were taking them out in the 8th grade. Giving them a choice to go back to school would have a huge impact on their lives, because missing the like 4 years of high school and not graduating will lead you down a completely different life path than if you dropped that at 16 or even graduated. Like, you just have more opportunities if you stayed in high school. So I believe you should give them a choice.
I agree with Iman. We can see inside Massachusetts, I would relate it a lot to abortion. We can see right now abortion laws in Massachusetts where even if your parent does say no and you're at the age of 16, you could still sue for abortion. So I believe that you should be able to sue to have a right to be inside education, even if it does affect the parent's income and wealth. I feel that the child's liberties are more at stake there because it's their rights that are being tried. So I feel like they should be the ones to have the say.
Yeah, I definitely agree with that. I do think that 14 is a little young to be able to make a decision that's going to impact your life that much, because 8th grade, you're still very young. I think that maybe we should wait until you're about like 16, and then you have a better understanding. Then there's a study at Tufts University that was about voting rights that says that your brain is pretty much the same, and you can like make decisions based off the same thing between when you're 16 and 14. So there's not much there, but I think that making a decision that's going to impact your life that much, you shouldn't be able to make that young.
Thank you.
Let me ask a broad question. What does separation of church and state mean?
The separation of church and state is more of an absolutist view. It's where you don't have them conflicting with each other at all. And so we see this inside the Establishment Clause, really, when Madison was writing it, where you don't have them conflicting with each other, and where you don't have one that's like overly telling the other one what to do.
Yeah, some absolutist views are like, they just really hate religion. Like in one case, Levi Wiseman, basically they banned like prayer at graduation, and like absolutist views just hate the term God and hate all religious terms that like are in like used in schools, mainly actually schools, because in some non-preferentialist views, like there was this one case where they allowed prayer before a legislative session, and they just really only care if it's in schools or not. And I think it mainly is because of the parents, because their parents don't really want their children being like induced with these like religious like terms and stuff. Maybe like it's their choice, but it's mainly seen in schools and not other places like in the legislative.
So what about after school? After school religious clubs, or an after school, say, pro-life club or pro-choice club. How would you balance that there? So it's not compulsory. You don't have to be part of the club. What are your thoughts? And how would we relate it to the Constitution?
I'd look at that using the Lemon test. I feel like the Lemon test is a three-pronged test of does it serve a purpose? Does it promote or restrict religion? And does it oh, sorry. Could I finish?
No, go ahead.
All right. And then the third prong was does involve unnecessary government entanglement. I feel that if it does involve unnecessary government entanglement, then I feel that it would be a bit iffy if we allowed that. But I also feel that like
Time.
it does serve a purpose. So yeah.
Thank you, James, and thank you to the entire team. And congratulations to you and your teacher. Just a well-done presentation. And the judges now will be giving you their feedback.
What a terrific job. Really fantastic. You should be extremely proud of yourself. And I know your teacher is very proud of you as well. I was extremely impressed with the constitutional depth, the way you cited case law, going all the way back to the understanding of the framers. I loved your citing that the very reason why we wanted to have these religious protections are because of the need for democracy to work. I loved your understanding of the different levels of scrutiny, and that the balancing of individuals, the state's rights versus religious freedom really shakes down to what level of scrutiny applies. It is a strict scrutiny case or a rational basis case. Very sophisticated understanding. And then in our hypotheticals, when we ask these questions, almost every time you began with a case. You said, this is Wisconsin versus Yoder. This is Smith. This is Lemon versus Kurtzman. This is how I would analyze that. So you didn't just offer your personal opinion or what your gut told you. You went to the case law and then filtered through the piece of analysis in the case. So I thought it was just a very sophisticated, high-level conversation, and really loved it. And again, wonderful job.
I would agree. I think it was great. Everyone participated. You have an excellent grasp of the subject matter, an excellent usage of not just historical references, but new references as well. You mentioned that, Tufts University study, and I think that that's just, we're recognizing that things, these ideas evolve. Even though they are strictly grounded in what the framers mentioned, and that we can balance what was done with the framers and what we're discussing today. So I think that you all just had an excellent level of reasoning and showing that you understand the subject matter and understand the incredible complexities of these issues. So again, I think you all did a really great job.
Lovely. I agree with my colleagues. You went a little beyond just the pure academic approach. You also provided the history and some historical perspective, but I particularly appreciated the application, even at your local level, at your state level, and then you analyzed what's the appropriate age, 14, 16, but then again, there's a study that says 14 and 16, there is really no great differentiation. So maybe for future thought, it may be okay for them to have that decision. So well done. I liked how conversational your approach was. Congratulations also to your teacher for her assistance in the preparation. Lovely job. Good luck to you all.